Good morning, everyone. Before starting, I wanted to remind you that we have a live interpretation in English and French today. You just need to click the interpretation option on Zoom. Welcome, everyone, for this final webinar in this series as part of the launch of the French language version of the Global Case Law database. My name is Anderson Javier de Rossi de Leon, and on behalf of Colombia Global Freedom of Expression, I'm very pleased to welcome you today and to open this webinar on the protections and limitations of freedom of expression in the African system of human and people's rights that we are organizing in collaboration with Article 19 Senegal and the support of the experts. In this occasion, I have the honor not only to present the panel, but also of talking about our special collection on jurisprudence of the African system, which I had the honor to support when I was a legal researcher at Columbia. With that in mind, and so as not to disrupt the order, I will first talk about our initiative and in particular the launch of our French language database. And then I will share some of the key findings of our special collection. I would like to remind you that this webinar will last 1 hour. It is open to the public and it broadcasts on YouTube. You can ask questions throughout the webinar on the Zoom or YouTube chat. Columbia Global Freedom of Expression is an initiative of Columbia University created in 2014 by Lee C. Bollinger, then president of the university, to promote the highest international standards of judicial protection for freedom of expression and freedom of press worldwide. Our flagship project is the global database of case law on freedom of expression, which hosts over 2,200 cases analysis of 130 countries, and namely all the case law on freedom of expression of the Inter-American Court of Human Rights, the African Court on Human and People's Rights, and the Grand Chamber of the European Court of Human Rights. The French version already includes over 100 cases, is fully searchable, and contains information on a wide range of issues relating to freedom of expression around the world. In addition, new cases will be added every month. Our database is a valuable resource for legal professionals and anyone wishing to learn more about the case law of regional human rights courts, national tribunals, UN bodies, and other quasi-judicial bodies in different languages and on key issues such as hate speech, elections, internet blackouts, slaps, violence against journalists, among many others. The database also contains translations of 6 special compendium documents. These special reports documents systematize the jurisprudence of the Global Freedom of Expression database, providing a global perspective of some of the most important legal decisions adopted by national and international courts on relevant freedom of expression issues. It is important to note that the French language database and this webinar series are made possible through the support of UNESCO's multi-donor program on freedom of expression and the safety of journalists, and the Cyrilla Collaborative with the funding from the Center for Intellectual Property and Information Technology Law, the University of Strathmore in Nairobi, Kenya. I would therefore like to thank them warmly for their support. Now I will speak in English for the second part of my intervention. For those who want to continue listening in French, you can select the interpretation button and switch to the French channel.
For the second part of my intervention, I would like to share a brief overview of our special collection paper on the case law of the African system of human and people's rights as a prelude to the intervention of my colleagues. First of all, I would like to speak a little bit of what is the aim that we have with these special collection papers. But before I do that, let me make sure that everyone can access the chat. Let me see. Yes. So now that we can all chat with each other, I remind you all that you can write your questions in the chat, both here on Zoom and on YouTube as well. So the work that we do at Columbia Global Freedom of Expression has a lot to do with identifying the global trends on all the jurisprudence that we analyze on a everyday, on a daily basis. So it's not only having the case analysis, but what do we do? How do we make an easy access for all the audience that come every day to our webpage? So back in 2021, we decided that we wanted to do a special collection paper series. And in this series, we're kind of bringing together either from specific topics, as we do, for instance, with internet shutdowns or with hate speech, all the jurisprudence dealing with these issues and the particularities that we have identified in the decisions, or we have done regional courts decisions. And this is exactly what the paper on the African system is. It's a regional decision where we wanted to identify how the jurisprudence from the African Court and the African Commission on Human and People's Rights connects to all the regional and international jurisprudence on human rights, in particular on freedom of expression and access to information. So when you look at our paper, the first things that we do is situate the African Court and the African Commission and try to present to the students, the lawyers, the journalists that access to the paper with the general information of what is the mission, what is the mandate of the commission, and what is the mandate of the court. Of course, it would help people to understand that unlike other systems, for instance, the African system does have a commission, which is similar to the Inter-American System Commission, and that has an impact in the way the jurisprudence evolve. But of course, that is a difference for the audience in Europe that will be more familiar with a system that does not have a commission, and thus only the courts is the one issuing decisions and kind of developing these trends. Once we understand the mandate and once we present it, we then go to a section that addresses global perspective. And in that section, we basically connect how the African system has been contributing to some of the greatest trends in freedom of expression jurisprudence. And there are key aspects to that. For instance, we have seen how with the European court system, in the European court system and the Inter-American system, there has been a lot of jurisprudence on the exceptional nature of criminal defamation and the excessive imposition of penalties. And this is something that we have seen how the African system has also addressed it. So in a way, the work that we have done here has kind of underlined those aspects where the African system has contributed to these global trends on freedom of expression and kind of solidifying these international standards and giving them a rather global perspective in that sense. But it's not only comparing how, let's say, the African system kind of have this judicial dialogue with the regional, with other regional and international counterparts, such as organs from the United Nations system, including the United Nations Human Rights Committee, but also this case analysis systematize the jurisprudence of these two African organs in their own rights. Let's say it will go how some thematic issues have been developed by the court and the commission, and how specific cases have been even gone beyond what has been established or what has been already addressed by other regional courts and tribunals. And I will give you an example. For instance, our papers talk about how the African Commission has addressed the right to receive information in deportation proceedings. And that was the case of Kenneth Good versus Botswana, which was decided in 2010. This was a case in which the African Commission kind of brought and developed the interrelation into the right to receive information in a case that a journalist was being deported without having the information why this was happening. And of course, the access to the information in the same process, in the same deportation proceedings. So this is a case that, for instance, we don't have an equivalent in it in any other of the international systems, but we kind of relies and highlights how the African system, and in particular the Commission here, can go or has gone beyond to establish the importance of this right to access information in that context. One of the things that we have also identified is how there are common trends of freedom of expression regardless of the system. For instance, how has been very relevant to talk about the specific tolerance that political leaders and of government officials need to have when they're being criticized, either by journalists, but also by civil society. And that also connects to a very relevant issue of violence against journalists. There are not as many decisions on these issues from the African Court or African Commission as it is as they are from other systems. However, we need to bear in mind that there are not as many decisions in general when we compare, for instance, to the European system. We have tons of decisions, or the inter-American system, which has fewer than the European, but still much more. So one specific case and one issue that I think it's relevant if we're going to talk about limitations is that in some cases there's not, let's say, the same position on non-state actors that we have seen maybe in the European Court of Human Rights, where we can talk about due process and positive obligations to prevent some sort of violations. This has not happened in, for instance, in Zimbabwe, Human Rights NGO Forum versus Zimbabwe, when the court said that there's a holding saying that a political party was considered independently from the state, so the commission of a human rights violation by the party did not amount to a violation of the freedom of expression. I think this is a clear position where non-state actors are not supposed to be violating or cannot be held responsible, or the state cannot be held responsible for the acts of a non-state actors. I believe that maybe in an inter-American perspective or the European perspective, there would have been question of what was the act of the state, how did the state respond to that? And of course, there would have been a link between the acts of these non-state actors, which is already exercising, let's say, a public role. In this case, it was a political party, but was, let's say, separated from those acts of the state, and therefore the state of Zimbabwe was not declared responsible for violating the human rights of the applicant. So while we were analyzing the whole jurisprudence, I think that for me was one of the key distinctions of the approach that the African Commission has taken to non-state actors and freedom of expression. But if we look at other topics, we will realize that it's very similar. For instance, when we talk about freedom of express, content regulation, and indirect censorship, the Commission has been very keen and clear in saying the state has the right to establish, for instance, conditions for people to have a license, for instance, for papers to have a license. There are a couple of cases dealing with that. However, those requirements need to be clear. They need not to be discretionary, and they need to avoid any kind of indirect censorship or be, let's say, be too harsh on the person who's going to ask for this license, that it actually ends up precluding people from the right to express themselves. So if we look at that, it's very similar to what has been established by other international tribunals. So there is a clear understanding of this judicial, let's say, the judicial dialogue between the court the African Commission and also the court and other regional bodies. Then I must say that in terms of the jurisprudence from the court, there are not so many court decisions dealing with freedom of expression, but a few of them, and this is for me to end because I don't want to take some time from the question, but some of the key issues from the African Court of People of Human Rights has been dealing with the genocide denial. For instance, if we look at Ingabire Victoire Umuhoza versus Rwanda, this was a case where the court said that there wasn't protection to people. There wasn't an international law protection to people denying genocide, but of course there needs to be a contextual application of these rules and understanding that it is not, it does not suffice to condemn someone on a merely social context and history there. So that's like a very good case to study the connection between hate speech, in this case, not hate speech, but genocide denial in the jurisprudence of the African court. There was the Lohe Isa Konote versus Burkina Faso, where from the side of the courts, we have this acknowledgement of public figures having to tolerate more severe criticism, which is, let's say, already a long-standing standard in international law. But for the first time, the court had the chance to kind of acknowledge that. And there's a few standards as well on the right to receive information, which was very interesting case versus Benin, in which the court basically said that it was a constitutional amendment process, and the court established that because the people of Benin were not consulted in this process, and it had such an importance for the people of Benin, that process actually violated the amendment of the Constitution, violated the right to receive information under Article 9. So I think that is a very key contribution to the access to information jurisprudence on the side of the court, which can be replicated in other, let's say, referendum and amendment proceedings across the world. So I will leave it to that. And now I have the honor to pass the floor to Alfred Boulakali, who is Regional Director of Article 19, both in the Senegal and West Africa office. So I will give it to him so he can introduce my colleagues, speakers, and moderate.
Thank you, Anderson. Good morning, ladies and gentlemen. Wherever you are, wherever you're taking part to this panel from, who is this panel, which is presenting the French language database regarding the African systems in the protection of freedom of expression. I am very honored to be able to moderate this discussion. And Anderson, thank you for introducing this database and a few cases that illustrates the position of the African system, be it the court or the commission, regarding the freedom of expression on the continent through the cases that you mentioned. So you mentioned cases in Benin, Burkina Faso, Rwanda, and elsewhere, with an approach and connection with Europe and America on similar topics. So to discuss this further, we will have with us Ms. Sarah Peters and Dr. Silaso. Sarah Peters has different legal professions, legal titles. She is associate at the Pan-African Lawyers Union. So the Pan-African Lawyers Union, translating it in French. And she has worked on different situations in Africa, namely the Judicial Center in Tanzania. She also worked at the Bar Association in Antwerp in Belgium, where she has worked for more than 9 years and works there since 2016. She is a person who really knows the African system, especially Eastern Africa, and she will talk us through these topics. I just wanted to remind the people who just came that we have interpretation in French and English. Just write something in the chat if you cannot connect, and we will help you with that in case. Thank you. And if you have questions, just write them in the chat and we will have the possibility to get back to you. And you can also raise your hand if you want to ask a question or make a comment. We also have with us Dr. Sila So, who is an associate researcher at Article 19, West African office. He's conducting the global research, and he is mainly law lecturer at university, and he also was a director of the Institute of Human Rights in Shidakandajop. He wrote a lot of articles regarding the African system, the way the African system deal with human rights and freedom of expression. He's also associated with writing manuals on human rights. You can find many of his publications online. So thank you very much. We will start with Sila So. Dr. Sila So, can you take the floor and talk to us about the way, the mechanisms, African mechanisms, and how they deal with freedom of expression and access to information. Thank you. Dr. Sila So, thank you. Thank you very much. Director, good morning, everyone. So generally speaking, I think Anderson mentioned many aspects as an introduction regarding the African system on human rights protection. And we must say that this system, compared to other systems, the European and the American one, all these systems are evolutive systems. The African system of human rights protection is not an exception. So beyond the charter, the African system had other protocols and protocols that reinforces rights and mechanisms. I'm mentioning here the Maputo protocol that gives elements on this. We also have a protocol on the rights of elder people that was just introduced. We also have Awaka protocol that reinforces judicial mechanisms. So generally speaking, the African system is a concurrential competitive system, and it implements two mechanisms. The first one, so on one side there is the Commission and the other side the African Court. And the particularity of the African system is that there is a hierarchy. The Commission to the main mission, and the African Court, as it is said in the Awaga Protocol, it aims at completing the existing charters. The African Commission, and it is important to speak about it, has mentioned special work groups and special reports There is a special rapporteur on freedom of expression and the right to access information. And in compliance with this mandate, these rapporteurs think about these aspects. The African Commission and the rapporteur are working substantially on many instruments that were adopted. I want to mention Loi Deep, the law on freedom of expression, and also the right to access to information, that are important instruments that are developed. When we talk about the judicial mechanism, the protection that is offered, the rights that are guaranteed, access to information or freedom of expression are that. So this is a protection that is of a higher level compared to other mechanisms. I'm talking about the European and the American ones. I wanted to remind you that I'm mentioning the jurisprudence, which we inherited because the Commission is more than 20 years older than the Commission. So the court based itself on the existing laws. And I am mentioning here the case against Eritrea. And this is one of the democratic principles to counter government's excess when we talk about freedom of expression and access to information. Globally, these are rights that are broadly subject to limitations. And this is already mentioned in the Charter, but the African Commission and the court specifies these modifications and limitations in its the court went back on the proportionality principle and the necessary character of these limitations in its decision. In a specific case, the court mentioned the reasons for the restrictions that need to be based on a legitimate interest, and the negative consequences of this restriction need to be proportionate. So we built a system on the recognition of these rights, but also the adaptations that are necessary. I was saying that the African Court and the African mechanism of human rights protection present a higher level of protections compared to other systems. For the reason that other systems admit measures of derogation, I want to mention the Article 15 of the European human rights law and the United Nations Pact on Human Rights Law. And this allows for a derogation, exemption to these rights. And the particularity of the African system is that there is no exemption, no derogation possible. In any circumstance, the state of law need to guarantee these rights. I think it is a plus of the African system, and it is something that wants to guarantee the access to information and freedom of expression. So on the first part of my intervention, I wanted to show how, in terms of jurisprudence of the court and the Commission, the court managed to frame these limitations. Obviously, in the case of our advocacy, Article 19 or NGOs, we always send back to this to reinforce and always go back to these limitations that we can find more or less in the website. Thank you, Dr. Sila, for presenting this maximal protection of the freedom of expression and access to information by the African system compared to other systems on other continents. And thank you for showing this competitive protection and hierarchized protection. Now, from your perspective, even if there is this maximal protection, I'm allowing myself to use this word with regards to what you said, are there limitations that you could identify in those systems? Thank you. I think that despite these maximal protection, I think that the African system has a lot of challenges, many challenges. I wrote a paper where I had to present the incoherence of the protection of human rights. There are two incoherences. The first one is the intrinsic one, an inconsistent element that can have an impact on the court's functioning. And the main limitation is the fact that between commission and the rules of receivability are not the same. So they're not the same. The admissibility are not the same. Take Article 36, second paragraph of the court mentions the different competencies of the courts, and this asks the NGOs to take decisions on access to information. If you take Senegal, for example, there was no declaration of acceptancy of competency for NGOs. So today, we cannot go before the court because Senegal did not sign this disclosure. Senegal does not have access to information or freedom of expression. We cannot go before court. We cannot take it to court. And that is why the court was set up, is because the commission communicates and then there is a decision made. Secondly, I would like, yes, Sila, you can speak for 2 more minutes before we go to the last question. So external elements that can have a significant impact on the mechanism, we discussed it, is the absence of organization of these different, so the absence of layout, the dissemination of community organs, and these community organs have community jurisdiction. And there is the ECOWAS and others, and these judicial organs have a tendency to have their own competency in terms of human rights. I'm taking, for example, the ECOWAS that has its competency, but does not have a basis treaty, which means that the ECOWAS today interprets the African Charter's provisions without having the competency to do so. And this, to an extent, can lead to a divergence in interpretation between the Commission, the court, and the ECOWAS today. ECOWAS interpreted and took 2 decisions regarding the internet, and but now the court. So the ECOWAS interpretation is not warrant of the Charter's principles. So it is not something fundamentally negative. I think that Professor was saying that before. The system needs to be consistent from top to the bottom. So the warranted rights need to be respected. So then we have the reservability rights. And if you want to go before, the admissibility rules are not the same at ECOWAS and at the Commission. Just let me finish. because the ECOWAS court does not have the same requirements as the Commission and the courts. So today, this has an impact, a significant impact on the Charter's decisions. Thank you. Thank you, Dr. Sila, for strengthening this competition between different African organs, the regional community organs with the continental ones, and also the problematic of the admissibility rules that are not the same, and create inconsistencies, as well as intrinsic factors, external factors that more or less act on the system and underline the challenges and limitations. Just in 1 minute, could you tell us why the African jurisprudence and the NGOs works basing on the Article 19's work? How do they work together? Can you talk about this for 1 minute? We will go back to this when we have the comments and questions. I think I mentioned 2 elements. Article 19 is an organization where NGOs have an observer status and they work with special rapporteurs in the production of soft law. I mentioned earlier the Declaration on Freedom of Expression and Access to Information, that are documents that guide the state's behavior regarding contentious affairs now. The Commission is helping applicants, and there are always communications that are made. And now, thanks to the rules and the bylaws, we have the possibility to work with the Commission to develop contentious. Thank you. I will mention other collaboration mechanisms on denunciation, for example. Thank you, Sila. I wanted to remind all the participants that questions can be asked in the chat, and we will mention them after the intervention of Sarah Peters. Dr. Sarah Peters, hello.
Yes, hi. Thank you.
I would like to give you the floor now so that you can continue after Dr. Sila and give your perspective. Talk about the protection of freedom of expression in the African system. You will have the possibility to draw parallels between how it's happening at the court, the Commission, the Continental Commission, but also at the Western African Court. You have the floor now.
Thank you so much. And first, I want to say that I'm very excited for the database that's been developed, which we can definitely use in our pending cases. And also thank you for the remarks by my colleague for Article 19 in also linking to the access and admissibility requirements at these courts and the difficulties that come with it. So my first part of the presentation would be about these African international judicial mechanisms, what they've been doing in regards to the safeguarding of freedom of expression and access to information. I will mainly focus on the African Court and the East African Court of Justice, as this is those are both the courts that PALU engages with the most. And the second part of the presentation will be on the challenges these courts face in executing their mandate and how we, as lawyers, CSOs, and NHRIs, can remove these obstacles, or at least try to assist in removing them. So first, quick on the African Court, started in 2006 and received its first application in 2008. So it's a relatively young court. And its mandate is to give interpretation and to apply the African Charter on Human and People's Rights, but also other human rights instruments. What qualifies as other human rights instruments is very broad. So for freedom of expression and access to information, amongst others, this includes Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, but also soft law from the African Commission Declarations, for example. The successes from the African Court, I'm going to refer to the findings of the special collection paper on the jurisprudence of the African Court. I just want to add one more, that Palu currently is litigating a case at the African Court concerning the presidential elections of 2020 in Tanzania. And one of the violations amongst the violations that occurred in this case is regarding the internet shutdown and internet restrictions during election time. So this would be very interesting and very useful if we can keep this conversation ongoing and keep sharing information. Also, I want to say as a success or as an initiative showed by the African Court on freedom of expression is that they have free massive open online courses, and one is currently ongoing. It's on freedom of expression, artificial intelligence and elections. So I also encourage to follow these trainings. Quickly on the East African Court of Justice, started in 2001 and received its first application in 2005. Its mandate is to give interpretation and to apply the EAC treaty. Now, formally, the EAC, the East African Court of Justice, is not a human rights court. However, within the EAC treaty is a citation to the African Charter on Human and People's Rights, and they use it as a source for the recognition, promotion, and protection of human and people rights within the community. As almost 90% of the cases filed in the EAC currently are based on these kind of violations as human rights violations. There's been discussion on expanding these EACJ's jurisdiction to these human rights violations, as de facto they've already been acting as a human rights court. The successes of this EACJ EAC court, I can refer to many. I'm going to pick two just in interest of time. For example, there was the case of the Burundi Journalist Union versus the Republic of Burundi. It was a case of 2013. And the 2013 amendments to Burundian press law, the EACJ has ordered that there was a breach of the EAC treaty, referring to this human rights reference. And in 2015, the amendment brought the Burundi press law into partial conformity with the decision of the EACJ. The same with a Tanzanian case, was a managing editor Mseto case against the United Republic of Tanzania. And it concerned a Media Act of 2016 that gave the minister very broad discretion to prohibit a newspaper from publishing or disseminating information. And the Mseto was banned from publishing for 3 years. As a result, the EACJ decided this restricts press freedom and freedom of expression, therefore a breach of the EAC treaty. And the ban was successfully lifted in February 2022. So it took a while, but it was successfully lifted. I think jurisprudence, we have to have more time to deep dive into it, but other recent initiatives that the EACJ took also to demonstrate their journey towards safeguarding freedom of expression was in 2022. EACJ signed an MOU with UNESCO to collaborate on various programs on promoting freedom of expression, access to information, and rule of law. And then in October 2022, and then very recently in March 2024, where our CEO also attended, they did regional media trainings during which they establish jurisprudence of the EACJ. They go through it, they familiarize different actors with their jurisprudence and their working mechanisms and so on, and also include the role of media in implementation of their decisions to really create this synergy of actors. Now, my second part, and this is the main part on these courts, are the challenges they face. The courts are there, they have their mandate, but there are difficulties to access them, as already said by my colleague, and there are also difficulties in implementing their decisions. So first on the access, especially for the African court, as my colleague already said, individuals and NGOs can only access the African court for a contentious case. They can only file cases against EU member states. Only EU member states that have filed the declaration concerning Article 34/6, which means to allow CSOs and individuals to start a case to directly access the court. So currently, there's only 8 EU member states that have this, that parties of the founding protocol of the African, and while simultaneously also having this declaration filed, which makes it very difficult and very limited to access this court in that sense. The same with the withdrawal of their declaration. Most recently, Rwanda withdrew the declaration in 2017, Tanzania in 2019, Cote d'Ivoire and Benin in 2020. So this is not a good tendency they're going. Secondly, for the advisory opinion, at the moment, it's mentioned that EU member states can file advisory opinions and EU organs. And then thirdly, any African organization recognized by the EU. Paulu's unique position herein is that only Paulu so far has received this recognition by the EU. So this is also a limitation to the African Court. At the same time, to the East African Court of Justice, they have a time limit which is very strict. So if the violation occurs, you have to make sure you file your application at the ESCJ before the 2 months lapse, which is very brief. After violation, you have a process going on that you have to first find your safety. If it's a violation against your safety, you have to then map out how you're going to continue. Then you have to find a lawyer, then you have to find funding for this lawyer, and then only can you refer the case. So it's a very limited time in order to successfully establish your case. Also, there's a difficulty with language. As of now, African Court language, they use English, French, Portuguese, and Arabic, but the East African Court of Justice only English, which means if you file in the French language, you have to translate every attachment, every affidavit that you submit to support your case, which is not only time consuming, but also very costly. Another limitation of both courts is that the African Court and the East African Court of Justice do not have permanent judges, which causes a major backlog. Currently, for the contentious cases at the African Court, there are 342 cases filed and only 216 are finalized. The same with the East African Court of Justice. In first instance, there's 621 cases filed, but only 231 cases are decided. So this is very limited to both systems. Lastly, and this is the most important one and also touched already by my colleague, Article 19, the implementation. As both these mechanisms don't have an execution machinery of its own, they have to rely on the execution machineries that are present in the country where the decision needs to be executed, which means I think the African Court has shared with us information in 2022 that there was an implementation rate of only 7%. So this is a major, major concern. Even though you have these cases successfully gone through the mechanisms, if they're not implemented, it's very discouraging to, at most, the applicants. So this is the last part of my presentation. Like, so what? What should we do about it? And what is Paulu already doing about it? And I think one of the success stories is in the Konate case established. Oh, sorry. Yes.
Thank you, Sarah, for this brilliant presentation. I wanted to write that you're asking a question. What do we need to do? What must we do? I want this question to go back to all the men and women, all the participants that are following this webinar with other questions. You underlined the problem of accessibility, problem of the languages, problem of the time for some of these courts that are very limited, and the accessibility problem. So what do we need to do? We will open the floor now for discussion. So the participants can send their comments. We're very pleased to see your comments and your questions. Ladies and gentlemen, if you have comments or questions, please write them in the chat and we will give you the floor or raise your hand. We will give you the floor if you raise your hand. Questions can be directed to Sarah, Dr. Sila, or Anderson, and the comments can be on the question raised by Sarah and other questions that you might have. I just wanted to underline the fact that they cannot talk, they can just participate in the chat. Thank you, Anderson. If you have a comment, a question, just write it down in the chat. There is no question or comment in the chat for now. So I wanted to go back to the question by Sarah. For all the speakers of this panel. So considering all the challenges, limitations, and difficulties that were underlined, Anderson, Sila, and you yourself, Sarah, where is the way out? What is the way out for us?
Well, if you want, I can give it a
Yes.
try. First, I will say we need to start thinking how to reinforce these organisms, to reinforce the court and the commission, because the way that we do, and this has a lot to do with the work at Columbia, we analyze how the jurisprudence might be moving forward, how we may have so progressive decisions, but these decisions need to be implemented, and these decisions need to kind of produce an impact in the specific countries. So it doesn't matter how many decisions you have if actually people are not paying attention in the country. And I know that's something you're way more familiar than I am. So ratifying and kind of submitting the states to the jurisdiction of the court and the commission is highly important. And when they are part of the jurisdiction, making sure that the political organs in the states are actually paying attention to these decisions. I think that's where we should be focusing.
Thank you, Sila, if you can add to that. I think that more or less, as Anderson said, considering that the African court is competent only for a few states, we assisted these steps backwards in terms of competency of these states. So today the court is only competent for 10 states. So this is a problem. The commission, as I said, is effervescent in the promotion and protection of human rights, but it is very limited. So I think that today, until we get more information, African Union had recruited a consultant on how to reform all these systems and change all these systems and resolve the inconsistencies. So I think that our role is to continue to motivate and advocate so that the system is more consistent. And I think that in the long run, we should consider a connection between sub-regional and regional so that the protection is wider. And according to the areas, individuals and NGOs have more action margin than the court. At the ECOWAS level, the NGOs have a lot of intervention capability. So this is what Sarah said. And I think that the advocacy is really important to correct these differences in the system. Thank you, Sarah. You probably had something to say regarding this question. If you want to share something, you can do so now. And now we will we will share questions from the chat.
Thank you so much. I apologize for not seeing your comment on keeping time. I'm not good at it. but I'll do my best. So on the implementation, the second, like strategy implementation, strategy of
do you have an answer for the question? Sorry, there was a connection problem.
Can you hear me now? Is this better?
Yes,
Okay,
yes, we can
apologies.
hear you.
Thank you so much. So there's a whole roadmap on what we can do, as we all have an important role to play in it. And I want to refer to the Konate case, which was really successful in implementation because it's been picked up by the Constitutional Court of Lesotho, of the High Court in Kenya, the High Court in Malawi. And one of the key successes there was like the Special Rapporteur of the African Commission really took it to heart, the principle in the Konate on the decriminalization of defamation. And during every meeting, every mission, she mentioned it and it got picked up. So advocacy is definitely one of them, but we should also keep litigating. And while doing so, we should capacity build and find expertise and build on expertise. And this is, I think, one of the main things that Palu is really good at, is also surrounding yourself with experts. Know what you're good at, stay in that area of expertise, and then surround yourself with all other knowledgeable actors for all the other part and create really the movement and create really the synergy. So the countries, the national countries, can't do anything but listen, but notice, and but implement what we all have been asking them to do. So I think keep on litigating, advocacy, capacity building, also filing shadow reports, very important. So the real situation on the ground has been reported and not the mitigation. Thank you so much.
Thank you, Sarah. We do not have any time left, but I wanted to underline that in the chat we have congratulations by the participants to the panelists for the clarity and the richness of their interventions. So thank you for sending compliments to our guests. We have two questions that are complementary and to which you replied, Mr. Czech and Mr. Diouf, who asked what we need to do so that NGOs can access these courts. And there is another one regarding the jurisprudence, how to access it for the NGOs. I think that you replied to this in your three interventions, because the questions got to us when the panelists were writing the questions, were replying to the questions, sorry. Therein, how do the NGO of human rights advocacy can benefit from capacity building to better understand these courts and jurisdiction and be strengthened through advocacy? Anderson, you have the floor, and we will then conclude. Thank you. Thank you, Alfred. Thank you for this excellent moderation. Thank you, Sarah Peters. Thank you, Silaso, for your precious interventions and for the participants and their questions, their compliments, and for their presence today. Do not forget that this video will be published and streaming on the Columbia channel, the YouTube channel. You can also find the video of the other webinars, sorry, that we held in this series. We are also present in various social media, such as LinkedIn, Twitter, and I also invite you to share your contributions to the database and other comments that you would want to make on our website. We're reaching the end of this webinar. Thank you once again, and see you next time. Thank you, Anderson. Thank you to all the panelists, and see you next time, as you said. Thank you.
Thank you all.
Our guests.